Good morning, everybody. Welcome to the summer 2025 Bond Schoeneck King Special Education webinar. We're here today. My name is Jeffrey Weiss. I'm a partner in the Buffalo office, and I have four of my colleagues from around the state here today. We have Katie Stifler in the Rochester office. We have Candice Gomez, who's also the co-leader of our school law practice group down in our Long Island office. We have Andrew Mark in the Buffalo office, and we have Ann McGinnis in the Rochester office. So welcome. We're here today for a 90-minute webinar. We have a lot to cover, so get ready. We're gonna have a lot of substance today. We're going over the top 10 most important procedural rules in the CSE process. Those of you who live the special education life as a school administrator or a board member or just have a role in this process know that it's strongly driven by procedures. And so compliance with these procedures dictates whether or not we could stay out of, we could avoid liability, avoid compliance findings, and so on. So it's crucial that we identify the most important procedural rules and come up with strategies to meet them. So we have 10 rules today, plus a few extra at the end that we're going to throw in for honorable mention. Just at the outset, this is not a scientific assessment of the top 10. This is just based on all of our experience in the field. We came up with this list because we see these issues most often, and we see and we want to get ahead on compliance strategies to avoid potential hearing requests and complaints and so on. So let's get right to it. So let's start off with slide number 1. Okay, so slide number 1 deals with students in non-public schools. So if you are one of the few school districts without a non-public school in your geographic boundaries, you can kind of sit this one out, but you might come back at the end because there's a related rule here. So there's under Education Law 3602C, which is a controlling statute in New York for students with disabilities attending non-public schools. If a parent wants special education services for their child, he or she must submit in writing to the district of location, that's the district in which the non-public school is located, by June 1st of the preceding school year, requesting special education services. So again, if the parent does not request special education services by June 1st of the preceding school year, the district would have grounds to deny a request for special education. This is a real rule. This is not something, it seems harsh, but it is enforced, and there are very few exceptions to this rule. In fact, there's only one exception to this rule. It's if the student is initially classified after June 1st, then they can make a request after June 1st, but even that has a limit. It could only be up to April 1st of the existing school year. So just again, this is a serious rule. That there's only one exception. So what this also means from a practical standpoint, if a student enrolls in a non-public school after June 1st, they're too late. That is not an exception. And so ideally, the non-public school, if they're considering an enrollment after June 1st, they would say that. So just want to make sure everyone knows that, because you might have grounds on which to deny this request. I think the rationale behind it is to set your budget for 1 year to the next. You can't have these new costs come in mid-year. So, but this is a real rule. And I wanted to put, here's where, if you didn't have a non-public school and you thought you're off the hook, well, not so fast. If you're homeschooled, remember, a student who is homeschooled, not home instruction by the district, homeschooled by a parent with an IHIP, If that child wants special education services, he or she would be entitled to an IESP. That child the parent must make that request by June 1st as well, because under the law, homeschooled students are viewed just like non-public school students for purposes of special education. So if a parent decides to homeschool after June 1st and they already have an IEP, they're too late. Now, if you may want to, as an option, say, you know what, I'm going to let this late request slide and grant it. That's your discretion. You're not prohibited from granting that request. But keep in mind, if you do it once and the next you grant one late request, when the next late request comes in, if you deny that one, you might be subject to discrimination challenge. So keep that in mind. I'm a fan of, if you're going to let one in late, you got to let them all in late. So any thoughts from my panel on this one?
Jeff, we had a couple of questions.
Yeah. Mm-hmm.
So one is just clarifying that this is not the case for CSE placed, such as in approved private schools. Often the approved private schools are also considered non-publics.
Great. And this does not apply to all, because those are CSE placements.
And the other question is, if you have the annual review and the services are recommended, do you still need in writing?
Well, it's a great question. Usually, I mean, once the student's in the system, I think schools just forget about this. If they go from annual review to annual review to annual review, they forget about this, and that's their prerogative. But technically speaking, you don't have to. And ideally, you send out a notice maybe in February reminding everybody. I think this is a bigger concern for an initial, to be honest, the first time they come in, or the first time they are entering that status. Maybe they were in a public school and they moved to a non-pub. But yeah, I mean, again, it's not so much a could, should, it's not so much a must. It's could you enforce it? And technically you can. I think it would be harsh if they're already in the system. But if there's an expectation from an annual review student that you're going to want something in writing, I think you want to make that clear at some point before the June 1st deadline to say, look, I want you to know we're enforcing this rule. But that's a great question. All right. So I think we approved privates are referred to as not yet. Yeah. So again, just so we're clear, a non-public school, this is for unilateral placements by parents, like a parochial school, a school in which the parent decides, I'm going to place that child in that program. This is not a BOCES program or a CSE approved program recommended by the CSE. All right. Well, I think let's go on to yes. And again, consistency is crucial. We're going to go on to the next slide.
Okay, great. I'm going to talk about the least restrictive environment standard. So when we are developing an IEP for a student, we have two legal obligations. We have to provide a free, appropriate public education where we are addressing all of the students' needs. But the CSE is also charged with providing that free, appropriate public education, or that FAPE, in the least restrictive environment. And that means as close to the general education setting in a student's home public school as possible. And we get a lot of hearing requests on least restrictive environment cases. I'm going to talk a little bit about some of those as we go through here. But the general rule is that we should not be moving a student to a more restrictive setting. And when I say restrictive, away from the general education setting, unless we've exhausted all supplementary aids and services for that student prior to moving the student. This is especially important for students. Well, we have to do it for all students, but it's complicated for students with behavioral and social emotional needs who may require more support. And we know they require more support that we can't give in their current environment, but the law is very stringent that we have to exhaust these supplementary aids and services prior to moving those students. If the move is due to some kind of behavioral reason, then we're required to conduct a functional behavioral assessment and implement a behavior intervention plan before we do that move to that more restrictive setting. The law doesn't say how long we have to implement the BIP for, but we have to at least implement it for a while. I usually advise at least one iteration of data collection to see how the BIP is going. The longer you can implement, the stronger your case is. If your argument is this is not the appropriate setting, the child needs something more supportive, more restrictive. Other examples of supplementary aids and services are things like personal aids. That doesn't mean that you have to give an aid in every situation before you go more restrictive, but that's something for the CSE to consider. Any other special education supports that we can embed into their current program, any accommodations that we can put in their current program. And the burden is on the district to prove that it's exhausted all options. And if you find yourself at a hearing where you're defending a recommendation for a more restrictive placement and the parents are challenging that, the burden is on the district to prove that we did do everything we could to make it work in that less restrictive setting. And we have data to demonstrate that it didn't work. And if we're unable to prove that, that could make it difficult to prevail at that type of hearing. So I know it's difficult, especially when a student is maybe in a crisis situation. We want to move very quickly with that, but it's risky to do that if we have not taken these steps to exhaust all supplementary aids and services. Any of my colleagues have anything they want to share about that?
Oh, I think you did a great job covering it. Thank you, Anne.
Okay, great.
Jeff, I think you're on mute. Sorry.
Yes.
There you go.
The parents, advocates, and attorneys are very savvy when it comes to this rule, and they are the key to success from the parent side is to coordinate with an expert or a behavioral expert or a outside BCBA, and that we're seeing that as the focal point of litigation, where the district tried everything internally with its own BCBA, and then the parent will say, "Oh, I've got another BCBA who doesn't work for the district, who, for lack of a better term, is even better," and they'll come up with great strategies, and it puts districts in a, do you draw the line at that point, or do you be patient and use the outside BCBA suggestions? And it's frustrating when it gets to that point, but sometimes there is advantages to slowing down the process and trying the strategies that the outsiders are suggesting.
Yes, I also see this become an issue with initial eligibility determination. So frequently, and especially with the younger students, we see for various reasons a delay in that referral to the CSE when students have behavioral or social emotional problems. And I understand why. From a developmental perspective, there could be a developmental reason why students are struggling in this way that's not due to an underlying disability. A lot of people feel that classifying a student with an emotional disability is a heavy classification to give, especially to a young child, although I think that we should fight against stigma against that and not be afraid of that classification. But the problem is, if you're putting a lot of building level services in place for that student before you're referring to CSE, if you're doing an FBA and BIP, if you're giving counseling, if you're putting an aid in all through your tiered RTI or MTSS supports, if you wait too long to do that, and if you refer to CSE and classify and get to the decision of, well, we've already done everything we could do anyway in district, we have to start looking out of district, or we have to start looking to a more supportive program, that's a sign that you waited too long to refer to CSE, because we really don't get credit for those pre-referral strategies that we put in place prior to an IEP when we're talking about exhausting all of these supplementary aids and services. So it's a balance of how long do you provide those building level supports with when you make that referral. It depends on the severity of need. It depends on the intensity of the supports that they need. It depends on the period of time that they need those supports. I would be more quick to refer for behavior and social emotional reasons than I would for academic reasons. I wouldn't take as long through that RTI and MTSS process for those behavioral and social emotional reasons. That's my opinion based on the status of the case law out there. We do have some slides on this on the next slide, please, Kathy. Thank you. So yes, these are just general requirements under least restrictive environment where we have to comply with the procedural requirements set forth in the IDEA. If we find ourselves at hearing, and we talk about going to hearing a lot because that's the worst case scenario where we have to defend the decisions the CSE made, it's very high stakes. We have to prove that the district offered that FAPE in two ways. Substantively, meaning the IEP is substantively appropriate to address the student's needs, but also procedurally, meaning that we followed all of the procedures in special education law, and failing to exhaust all of those supplementary aids and services could arguably be a procedural issue. It could also be a substantive issue as well. And we could not prevail under either of those reasons. And we know that under the FAPE standard that the IEP has to be reasonably calculated to enable the child to receive educational benefits. And like I said, we have to balance those two legal requirements of that FAPE in the LRE, the least restrictive environment. So one of the questions is, if a parent wants a more restrictive placement, but the CSE does not agree with this, would adding more supplementary aids and services help with this, even though the CSE does not feel the student is in need of more of them? Well, I don't know, maybe. The CSE has to consider all requests made by the parent, and the CSE has to consider the parent's point of view on anything and have conversations around that. But the CSE does not need to recommend or agree to provide what the parent is asking for. If the CSE has a student-related reason for, and always going back to the student's needs for saying that a student doesn't need something that a parent is requesting, we can say no to that. We have to put that rationale in our prior written notice letter for why we're saying no. We need to make sure we thoroughly consider the parent's point of view. Now, we just need to know that once we start saying no, we're drawing that line in the sand. If the parent doesn't agree with what we're doing, their options are to request mediation or a state complaint or a due process hearing. So we really want to be ready to defend that decision if we get to that point. And that's one of the reasons that compromising is very important with parents and CSE. And you're not going to find anything in the law about compromising, but that's from a practical standpoint. It's supposed to be the parents and the district together putting together a document. Maybe adding more to the IEP in the current placement could be a way to compromise, but it's not required if the CSE doesn't believe that that's necessary to address the student's needs.
And there was a question about how do you view these from the opposite perspective, which is when the parent wants a more restrictive placement and the district thinks it's premature.
Yes, that comes up as well. So the CSE is only required to program for the student for school-based needs. We can apply, for example, to residential programs for students, but under special education law, that's only when we've exhausted all potential day program options for a student. It's not based on needs at home. And that's sometimes hard to explain to parents when they're having a difficult time with their child at home. We do need to consider what's going on at home, but our obligation is to program for the needs at school.
And I'll just make one last comment on this. And you probably have to talk to your attorney about this. But if you anticipate a big fight over LRE that's going to be litigated, you need to figure out what will the pendency placement be, because sometimes depending on which direction the placement's going, the pendency placement might be advantageous to the district, which means what they hope it is. Sometimes they may want to change the status quo, and if they know that they're gonna be stuck in status quo because of pendency, that's relevant to figure out, gee, maybe we should slow it down because we're gonna get this to this point anyway. We're not gonna be able to move anyway, so let's try to do more before we litigate. So these get very tricky, a lot of strategy involved in these, and it's good to get ahead of them.
I agree, Jeff. And just to add to what you and Ann were saying, if we are anticipating a disagreement with the parent regarding least restrictive environment, one of the other things that we should keep in mind is to make sure our evaluations are rock solid. So if we have 2-year-olds evaluations that we're working from, and there have been significant changes in either the student's academic progress or behavior within that time, it will be more difficult for us to basically argue at a hearing that we've prepared an IEP that's appropriate. So we should make sure our evaluations really support the decisions that we're making, because that will have a huge impact on our likelihood of success during the case.
Excellent point. Excellent point. All right. I guess we're on to next
Okay.
slide.
Yeah, speaking of evaluations, so when we're talking about procedures, of course, we have to talk about timelines and doing things in a timely fashion. So some important timelines are particularly applicable to initial evaluations and the provision of services to students who are initially classified. So these rules are pretty straightforward, but they're important. So we know that under the regulations, generally the initial CSE evaluations has to be completed within 60 calendar days of the district's receipt of consent to evaluate. So there's a built-in exception, unless that's extended by mutual agreement between the district and the parent. Always best to get, if there's going to be an agreement, make sure there's some kind of documentation in that regard. It would be nice to rely on a handshake, but unfortunately, in today's world, and we're talking about regulations and disagreements with parents and litigation, even an email is better than nothing. So that's 60 calendar days to complete the initial evaluation within receipt of the parent's consent to evaluate. So there's the related rule is, okay, once those evaluations are completed, how long do we have to get services going? So the rule there is within 60 school days. So for students initially eligible for an IEP, the CSE has to provide a recommendation to the board and then arrange, and then the district has to arrange for those services to be provided within 60 school days. So we have 2 months to complete the evaluation and 3 months essentially to get services going. Now, sometimes an issue comes up, we've seen schools like to get that the CSE recommendation adopted or approved by the board before they get the services going, and then you can butt up against this timeline. In those cases, we generally say, probably almost always say, it's better to be in compliance with the 60 school day timeline than to wait, for that official stamp of approval, so that we're in compliance with the regs, if the student needs those services. One other exception to the 60 calendar day rule to complete evaluations that's also in the regs, if the parent repeatedly fails or refuses to produce the student, obviously we can't evaluate the student if the student isn't there. So that is another exception to that rule. Of course, we just want to make sure that we're documenting those things in case it comes up later. Now, regarding the provision of services, just keep in mind, and I think we all know this, but it's a good reminder, consent for an initial evaluation is not the same as consent to provide services. An initial consent for an evaluation is not the same as initial consent to provide services. Once that initial evaluation is done, you still need that initial consent to move forward with the services after that's finished. So a related rule or not so related rule when it comes to reevaluations. So the parental consent need not be obtained for a reevaluation if the district can demonstrate that it has made reasonable efforts to obtain that consent and the student's parents fail to respond. So what this means is if you request consent to do a reeval and you request multiple times and the parent fails to respond, under the regs, you can move forward. You can go forward with that reevaluation. Now you need to try a few times. One and done is not going to do it. So, letters, phone calls, and document those efforts. And if you do decide to move forward, our suggestion generally is to notify the parent, through a letter saying, hey, we tried, we contacted you, we made these efforts, contacted you on such and XYZ dates. We didn't hear from you. We're going to go forward. Sometimes districts are uncomfortable with this and many choose not to do it. And sometimes evaluators are even worried about whether or not they can under, their own licensure requirements. But, under Part 200, you can move forward with a reevaluation if the parent fails to respond. Now, if they respond and say they don't, if they decline consent, if they say, hey, don't do it, that's a different story. We're talking about situations when you don't hear from the parent at all. So, yeah, I don't know if my colleagues have anything else to add, but.
Yeah, Andrew, I think I'll just add that in relation to the meeting that is held to ultimately review the evaluations, there have been situations in which maybe for a student who has not been classified yet, maybe it's an initial evaluation or someone who's not familiar with the process, or maybe even a parent who is familiar with the process but just wants to be oppositional. It's hard to get that parent in the room or on Zoom for a meeting. And school districts will miss the deadline because they will say, well, we've tried to reach the parent, we've called, we've emailed, and we just can't get in touch with them. And before you know it, we're a month past the deadline and still no meeting has been held. I'm open to thoughts from my colleagues, but my general practice is to have the district, after it's made enough reasonable attempts to reach the parent, go ahead and schedule the meeting and send out the meeting notice. And then at that point, let the parent decide that they're not able to attend the meeting. And then, of course, you can reschedule it. But I think it's always better to have some documentation showing that we were ready. We had a meeting on the books, and it was the parent who, for whatever reason, decided that they could not show up on that day. So we had to postpone it until a later date.
Yeah, and that's funny, Ken. That's one of our other rules later about going forward without. So the parents, sometimes with special ed, there are competing rules, and we're saying, which rule are we going to violate today? Because if you, that's why I think in the scenario you gave, the perfect score, the win would be, if the parent's not there, to comply with both is to have 3 meetings, schedule it 3 times before this, and then go forward without the parent. If you do that within the 60 school day deadline, then you have a chance to say we've complied with both rules. I think where schools get in trouble is they schedule the meeting the first time on day 59. The parent's not there, and they go, "Uh-oh, I got one more day to have this meeting." And I think that would be a trouble. If you ask me, I think having the meeting without the parent, if the parent wants to attend, is the bigger violation. That's like the number one procedural violation, arguably. But then again, what if CEQA, regional associates, are monitoring your compliance with this 60-day rule? Like, pick your poison. It's tough.
Yeah, no, I agree with you, Jeff. And when I say go ahead and schedule the meeting, I want to be clear that I'm not saying go ahead and have the meeting without the parent the first time around. I'm saying have it scheduled on your calendar so you're able to show a meeting was scheduled, the notice went out, and then if the parent doesn't show or says that they can't make that meeting time, then you reschedule it. And I totally agree with you, Jeff. Usually the 3 strikes you're out is kind of the rule we live by, where we're going to schedule it 3 separate times before we even think about having the meeting without the parent. But I think it's helpful to show that we had a date and a meeting set, and the parent was the one who unfortunately was not able to attend.
Absolutely.
We have a couple of questions.
Yeah.
One of the questions is, it was my understanding that extending the timeline for initial evaluation is connected only to suspecting learning disability in the regs. Has anybody heard of that? I'm not familiar with that. I thought that it was, and I didn't think there was a reason, because we don't typically say in our request for consent what it is that we're assessing for. We say the areas that we're going to assess in. So we're not usually explicitly testing for a specific classification, even though we are, right? But I'm not aware of anything in the regs that say we can only extend the timeline if it's for a learning disability.
Right. I'm not either. And also, I wasn't sure if, I didn't know if that was for, they were comparing the timelines for an initial eval with a re-eval. I didn't know if that was the angle either. I wasn't, it was written strangely. And that's a
Oh.
whole other issue about what's the timeline for re-eval, which is much less clear than the initial. In fact, I challenge anyone to tell me with clarity what that rule. It's not. It's very poorly written in the regs.
Another question. Oh, here's a good one. Here's a good one. Can you speak? They're all good, by the way, but can you speak a little bit about when a parent changes their mind after making a referral and also providing consent to evaluate? So I think this is essentially asking, can a parent revoke their consent to conduct an evaluation while we're in that evaluation stage? And there's actually nothing in the regs that says they can do that. The regs are
Right.
silent on that.
It's read. It expressly, they say you can revoke consent for services unequivocally, but it doesn't say it. So and I remember, yeah, I don't think technically they can. So what would happen? And so what would you do if the parent says, I'm just not going to produce my child? So you just let it time out and you just show up at the meeting with no data?
Yeah, I would just document that.
Yeah.
Yeah, and that's probably the technically correct thing to do. In my experience, many districts allow parents to revoke consent for evaluations. I get this question a lot, especially after the evaluations have already been completed. What do we do? And I say, well, you can't undo the evaluations. They've been completed. You could go to the initial eligibility determination. The parent doesn't have to give consent for services if they don't want to, if the student is found eligible.
Yep. And there was something also with someone once, we don't see the district side of the world with their portal and their system, but somebody once told me that there was no category in the system for revoking consent for an evaluation.
Yeah, probably because there's nothing in the law about that.
Yeah.
Yeah.
So they would say, it's like they said, well, we're going to count it as a withdrawing the referral. And I don't know if that's sort of cheating.
We have a question. Can parents refuse the 3-year reevaluation? Yes, parents have the right to give or not give consent to any evaluation. If the district wanted to override it, they could initiate due process, but that's a pretty rare thing that districts would do. If a parent requests an FBA during the summer, but the student is not in a program, are you okay to wait to send consent because we would not want to start the timeline during a period when we cannot collect data? I think that's semantics. Waiting to send consent for starting the timeline. There's an argument that once somebody makes a request, that's when that 60 school day timeline starts. So if somebody says, I think my child needs a BIP, I'm making a request to consider this, there's an argument that that timeline starts at that point. Could we make an argument that the timeline doesn't start until we get their consent back to do that FBA? I guess we could, but it's risky to delay that. I understand the practicalities. That comes up with FBAs a lot. When you have to do an FBA when a student is suspended, or if a student's on home instruction, it's difficult to do FBAs when students aren't in their learning environments. Sometimes if you're up against deadlines, you have to do the best you can with the data that you have, collect data that you can. You could write right within the FBA the reason that observational data couldn't be collected in the school setting. Usually, depending on, unless it comes in very early in the summer, you're going to at least get some school days within that timeline where you can collect some data. I know collecting data at the beginning of the school year also isn't a great time to do that for FBAs, but you have to do the best you can. If you write within the FBA the reason that full data couldn't be collected and say if determined necessary, more data will be collected and the CSE will reconsider, that's just a way to cover your bases.
All right.
Should we move on? There's a
Yeah.
few more, but
Let's move on.
Okay.
Yeah.
Okay, good morning, everyone. So the topic that I am covering is discretionary CSE members. So we all know that we have required members of the CSE, but in addition to those folks, we also have discretionary members. And these are people who either the district or the parent has deemed to have knowledge or some sort of special expertise regarding that student. So the key point here is that the regs don't expressly say that the district can prevent the parent from inviting a discretionary member in the same way that the parent can't object to a discretionary member that the district decides is relevant. The other important point is to make sure that any discretionary member, whether they're invited by the parent or the district, is on that CSE meeting invitation.
So, couple of Katie, so what I've seen historically, you know, the you can't object. It's a very powerful tool, and I think this comes up a lot for divorced parents or when there's a custody order. It's important that we figure out who is the parent, because that's the decision maker who can invite other people. And the angle for, let's say there's one parent with custody and the other is non-custodian, the custodial parent's the parent, is the parent, unless the hearing or the order says something different. And so if the parent, the custodial parent says, I don't want the other parent at the meeting, the district can invite the other parent. And the parent cannot block that from happening. So we see that happen a lot. And that's where this rule comes up. That setting is this rule's finest hour, because this is where it really gets put into place. And there's some case decisions that support the notion that we should always, district should invite the non-custodial.
Yeah, I think that's right, Jeff. And an interesting part about this regulation to me is that it says both the district and parent may invite other individuals whom they determine to have knowledge or special expertise regarding the child.
Yeah.
And that definition of knowledge regarding the student or special expertise is not really clearly defined. So what does it mean to have knowledge of the student? Does it mean that you've taught the student? Does it mean that you kind of know them in a family setting or in some type of athletic setting? It's not super defined. And I came across one interesting situation in which a mother wanted to bring, I believe it was 4 or 5 other individuals to a CSE meeting. Some of the members were part of the church community that both her and her son were a part of. And then there was a athletic coach that had worked with her son. And she was basically trying to bring other individuals that could speak to the different parts of the child's life to show how he was behaving and acting in those different settings. And while we never will allow people to become disruptive to the point where a CSE meeting can't take place, oftentimes it's kind of more practical to allow them and just make sure everyone behaves appropriately and has, you know, an appropriate amount of time to speak, rather than being challenged later with violating this provision by saying you did not allow someone with knowledge or expertise regarding the student to attend. If they have presumably some type of real life knowledge or input into the situation that could be helpful to the CSE, oftentimes it's better to allow it than to just outright reject it because we believe it could be an inconvenience to us.
Right. You're right. It's very powerful rule on both sides.
Looks like we do have one related question, which is what if a parent shows up to the CSE with an advocate and that advocate wasn't on the invitation?
I think you pull up a seat.
yeah.
No, yeah.
So parent attendees do not need to be on CSE invitations. Parents can invite whoever they'd like. They don't have to be on the invitation. And I see sometimes districts put people that the parent are inviting on invitations. I suppose that's okay, but there's no requirement to do that. And they're not people we're inviting. So I always wonder why we would put them on our invitation. If an attorney shows up, then you could push off the meeting and say that you'd want your legal counsel there. That runs into some issues if you're on a timeline, if you're in a timeline situation, and if pushing off the meeting means that you're going to violate whatever that timeline is. So you need to think about that. If it's like a manifestation, for example, and if you're going to run out of time for that manifestation to be held, then if you don't move forward with the meeting, then arguably the student can return until you can hold that manifest.
Yeah, I think many, many years ago, there was opinion letters somewhere where someone, I don't know if it was OSEP, said the district couldn't cancel the meeting if the parent's attorney shows up unannounced. I think that's crazy. And also, there are ethical rules for lawyers to give notice when they're showing up to with a and to speak with another party represented by counsel. So I would absolutely cancel the meeting if they showed up. I think another interesting thing is if the district, let's say the parent said, I want my private evaluator at this meeting. Now the parent could invite him, but if the district puts that person on the invite, does that give an argument to the parent, the evaluator, to say, thank you, you're gonna have to pay me for my time? And again, maybe I'm just being paranoid, but I would definitely avoid inviting them. They're the parent. You can invite whoever you want.
Yeah, they're not our attendees, right? Yes, we have attorneys around here who don't even introduce themselves as attorneys at CSE meetings. So if people don't know them, they don't know that they're an attorney.
Yeah, they'll say attorney acting as advocate, and again,
They'll
there are
just say advocate. We've had them just say advocate. Yeah.
And there are ethical
We
rules.
say attorneys around here. We don't mean bond attorneys. We
Yeah,
always
yeah,
Oh no, we mean
ourselves
attorneys.
as
I'm in the
attorneys.
Rochester office, so up here in the Rochester office. Yes, not bond attorneys. No, we're proud to be lawyers.
Yeah,
Let
That's right.
everybody know.
All right, I think we're on to the next one.
Great, thank you. So the next rule is less common mandatory CSE members. So Katie just walked us through some of the discretionary members of the CSE, but there are some other members of the CSE that are actually mandatory, but they may not come up as frequently as the typical kind of special education teacher, regular education teacher, parent, the people that we typically think of as the core group of CSE members. But we should be careful to remember that a parent may request in writing within 72 hours of the CSE meeting that a physician attend the meeting. Now, this physician does not have to be a physician that the parent has contracted with or that is working exclusively with the family. This is a school district physician. In some school districts, we call it a medical director. That person may be especially important when it comes to a student who has medical needs that the parent either kind of wants some more understanding of how this IEP is going to address those medical needs, or some other issue that would be uniquely suited for a physician to weigh in on and to answer. A parent may also request in writing within 72 hours of the CSE meeting that an additional parent member of a student with a disability attends. Now, this additional parent member is someone who I want to be clear about is not an advocate for the family. It's not an attorney for the family. This part of the law, the regulations, was really designed to provide some type of support to a parent during the CSE process, with the understanding that it can be a daunting process, especially for a parent who has not been through it for years and years. I mean, when we think about it, we use a completely different language in special ed land, right? We're talking about IEPs, and we're talking about FBAs and BIPs. To someone who is not in this day in and day out, it could be very daunting. And having a parent member, meaning someone who is the parent of a student who has been classified with a disability and is residing in that school district, or someone who has been a parent of a child with a disability, and maybe that child has been declassified within the last 5 years, or the child has graduated within the last 5 years. Not to mention the fact that this parent member has been trained to ensure that the CSE is functioning effectively and able to provide some tips and pointers and understanding to the parent. That person may be requested to attend the meeting, as I said, to serve as some type of support and almost a translator to the parent. But I will say that we can reduce the need for parent members if we as a CSE take the time to really serve that role, meaning that we slow down the process a little bit. We explain all of the acronyms that we're using. We talk about what a least restrictive environment is, and really take the opportunity in a very respectful way to educate a parent so that they don't feel that they need a parent member or someone on their side, so to speak, because they don't understand and trust what the CSE is saying. We can really do a lot to kind of avoid the necessity for that person if we do more of the educating ourselves. In a case where the CSE recommends an out-of-district placement, a representative from the out-of-district placement must attend the meeting. This comes up very often. If the CSE is going to be exploring an out-of-district placement and you're thinking that it's probable, or if not even probable, it's something that can be expected to be the outcome of the meeting, that one of the options will be an out-of-district placement. We should have someone from that placement there to explain to the parent, this is what our school looks like. Here's how a typical school day will function. Our classroom structure is set up in this way, and the profile of our students looks like XYZ. It's very difficult for us to convince a parent or to help a parent to understand that what the CSE is recommending is a good recommendation if they don't have the ability to communicate with someone who is at that actual placement. Think about it. None of us would send our children to a school where we don't know anyone there. We haven't met any teachers. We don't know the principal. We don't know what the building looks like. So this supports the parent that same opportunity to gain some real understanding about the school. Many times, of course, it will go beyond that typical intake meeting and the other steps that have taken place regarding that placement. This is an opportunity to dig a little bit deeper and to teach the parent more about that out-of-district placement that is being first considered and then perhaps eventually recommended. And lastly, when the student is determined to be at risk of a future residential placement, the CSE must, with parental consent, request in writing that a designee of the appropriate county or state agency participate in this CSE. And this is important for us to remember because, of course, a residential placement is one of the most restrictive environments that we could recommend as a CSE. So if we're going to take that step to talk about a residential placement, we really need all the voices in the room weighing in and making sure that this is the best decision for the child, because we're talking about a very restrictive environment, and part of that process must include a designee from the county or state agency. I'll pause there in case any of my colleagues have more to weigh in regarding this slide.
We have a few questions. There's a question, I believe that this was about inviting representatives from out-of-district placements, if that would present a concern with predetermination. No, because you're making the decision at the meeting. If they're there, it's because you've sent out applications typically, and you're considering placement in there because the student's been accepted to that program. That's typically when we see people from outside placements participate at a CSE.
I
Yeah.
agree with that, Anne. And I would just say for us to be careful about the language that we're using during the CSE. So if we have one representative from one out-of-district program, we should not be conducting the CSE meeting saying, well, this is the program that Johnny is going to go to next year, and we have this person from that program here to explain where he's going. We should talk about it. This is an option that we're considering. We've sent out packets, we've done the groundwork, and now here's the person who's going to explain more about it before we make that an official recommendation. So I completely agree, Anne, that having a person there doesn't mean predetermination, but we also have to watch the language that we're using leading up to when the CSE actually makes that recommendation towards the end of the meeting.
Yeah,
Go
I want to and this is in relation to some of the questions too. So technically speaking, CSE composition issues are viewed as procedural, which means if we don't have someone who's supposed to be there, since it's procedural, it's not automatically a FAPE denial. It could be, but it's not automatically. In my view, the not having someone from out of district is it's very easy for a parent to say that is making it difficult for them to meaningfully participate without that person there. That's crucial. Now, if the student has been in, let's say it's a BOCES program, the initial meeting is absolutely crucial that that person be there. The second, third, fourth time around, if we don't have someone there, now I'm not saying don't invite them, but if they're not there, I think we have a better argument to say it doesn't rise to a FAPE denial because you're already familiar with the program. Again, not saying don't do it, but the first time you have that recommendation, it's crucial that they be there. And there's nothing more frustrating than kind of going back to, remember the LRE slide about do all this great stuff? Imagine you spend 6 months setting it up so that the current placement in district doesn't work. You have a great record. You recommend an out-of-district placement. You get the hearing request challenging that out-of-district placement. And the first allegation is there was nobody from that placement at the meeting. And we've already shot ourselves in the foot before we started. So to me, absolutely the first time is crucial.
Yes, and if you have an acceptance from more than one program, invite somebody from every program that accepted the student. That's another way to not predetermine, and you can hear out from every program, and the CSE can then decide which program, if any, is appropriate for placing the student. And there was also a question about, do we need to continue to have people from the program? Well, you need the students' providers at CSE meetings so that they can help you develop the IEP if the student is placed there moving forward. There's a question about parent members. Who's responsible for identifying and securing a parent member? Is that the responsibility of the parent? No, that's the responsibility of the district. And the district is supposed to have a list of parent members who are available in the community. They're parents of children with disabilities who are either in our community or a close by community. And they're approved parent members, and we go down that list and we see who's available and we put them on the invite if the parent requests one. It used to be back in the day that there were certain CSE meetings where we always had to have parent members present automatically, but the regs changed many years ago and now it's only on parent request.
Yeah, parents used to opt out. Remember, it was, we're inviting someone unless you opt out.
Right.
It's a great day for the staff in the special ed offices because that was a big time commitment.
Another question, it's not quite connected, but it's an important one. If a CSE recommends an out-of-district placement, can a parent decline? Is filing due process the next step? So no, a parent cannot unilaterally say that we can't make a recommendation as CSE. The CSE has to consider the parent's concerns, but ultimately, if we can't reach consensus, the chairperson makes the final decision, which could include recommending an out-of-district placement over the parent's objection. You need to be really sure you're ready for that. You need to make sure that you've done everything you need to do to be able to defend that, because if you're making that recommendation over the parent's objection, you're drawing that line in the sand where if they want to block that, they need to initiate due process or do something else to try to block that. So it's a pretty big deal, but parents cannot say unilaterally that a child can't be placed in a certain placement.
All right, let's go on to the number 6, please. Okay. Holding a CSE meeting without the parent, we spoke about this earlier. CSE we may meet without the parent, but only if we tried to convince the parent to attend and we failed, and we maintained a detailed record of our attempts. This is where the 3 strikes and you're out rule comes in. At a minimum, districts should cancel and reschedule a meeting 3 times while continuing to attempt to convince the parent to attend before going forward. it's not simply invite, cancel, invite, cancel, invite, cancel. You need some emails, some calls saying, please attend. We value your participation. We need you there. Some of the guidance on this says, go out to their house, go out to their work, convince them. Of course, no one's going to do that, but we need to show that we try to convince. And 3 times, and that's it. Honestly, even if you try 3 times, it's still risky. This is a rough rule. As a result, schedule your CSE meetings well in advance of any deadlines so you have time to go through these drills at least 3 or 4 weeks before the deadline so that you could cancel, reschedule a few times. It is it now. From a practical standpoint, 2 things. One, you know the parents who never attend. And I think there's a comfort level with, we're going to go forward without them, fine. And that's a risk, but it's an educated risk. But when it's, think about it from the perspective of, oh, this parent never attends or rarely attends, but they're not going to like this outcome. They're not going to like a new placement. They may get a lawyer one day, and the lawyer is going to say, wait a minute, you weren't at that meeting. They shouldn't have gone forward. So if you know or anticipate an agreement, try to get the parent there. It's very important. Again, this is one of the top CSE violations out there. So do your best, give yourself time, come up with strategies, find a trusted staff member who could convince the parent to attend. And if you get the parent at a meeting, just finish the meeting. It's a gift if they're there. Don't table it, just finish it.
Yeah, that's so true, Jeff. And sometimes we have to be creative with those parents that are harder to reach. Maybe ideally we would want them in the room sitting down with us. If that's not possible, try to schedule a Zoom meeting. If they can't make it to Zoom because the nature of their work doesn't allow them to be in front of a laptop, see if you can have it via phone. Have them call in and just listen to the meeting and give, a few words about, the progress that their child is making or any challenges that their child is making. Any type of participation from the parent is better than none.
Excellent. And pre CSE meetings don't count. If we had a informal meeting before on Tuesday, parent was there, and you had the meeting on Friday, we don't get the credit for them being there on Tuesday. All right. Any questions on that, or we can move on? If can parents give consent to hold the CSE without them? There's nothing in the regs that say that. You want to make sure you have a great record of trying to convince them, and you write them like, well, we appreciate you consenting, we still need you, and do that a couple of times, then go forward without them. Okay, we can go on to the next one.
All right, I think this is mine.
Yeah.
A notice of intent to seek tuition reimbursement. This comes up when parents have unilaterally placed their child at a non-public school, meaning a private school, and it's due to their disagreement with what the district CSE recommended for their child. And they intend to preserve their right to seek tuition reimbursement for that unilateral placement from the district. So the parents disagree with the CSE decision, they place their kid at a private school, and they want the district to pay for it. That's the short answer. That's the short description. When that happens, the parents have to give the district something called a notice of intent to seek tuition reimbursement. And they can't initiate due process to start the process to recover tuition reimbursement against the district for 10 days after they give that notice. And there's 2 ways that parents can give that notice of intent. One is to inform the CSE at a CSE meeting that they're rejecting the CSE's recommended placement and they intend to enroll their child in a private school at public expense. Parents sometimes say this at the end of a CSE. They have it's clearly a written out statement that they read. What you want to watch out for is they disagree, they reject what we recommended. You want to hear some kind of language like that they're enrolling their child in another place because of that disagreement, and they're reserving their right to tuition reimbursement. So they're either going to enroll at public expense or they reserve their right for tuition reimbursement. If you hear anything like that, that is a notice of unilateral placement. And you cannot end that CSE meeting until you make sure the IEP is the strongest IEP it can be, because that is the IEP that you would be defending at due process. So when parents give written notice, which is the second way that they can do it here, where they write us a letter, we usually say that within those 10 days, we can convene the CSE to address their needs. But parent attorneys make the argument that when they give verbal notice at a CSE, we're already at a CSE and we don't get that second that second option to reconvene again that we do for written, which is why I'm saying if you hear that at a CSE, don't end that meeting until you make sure that IEP is very, very strong. If you get a written notice where they say the same thing, they reject what we recommended, they're reserving their right, they're unilaterally placing, they're reserving their right to tuition reimbursement or payment by the district, that's a good time to call your attorney and to make sure that we take the steps together to place the district in a position where it can defend whatever may come for due process. So you have 10 days to reconvene the CSE. That's what we should, in almost all cases, reconvene, make that IEP be as strong and legally defensible as possible. We typically respond to the parent in writing and say something about reconvening the CSE. And that would be the IEP that we defend if we were to go to due process. This can be tricky when a student is not classified. So if you get this for a student who is not classified, you need to refer them to CSE immediately. And if you can, and I've had districts do this, try to have that evaluation done and convene that CSE meeting within 10 business days. Hard to do, but I've seen it be done. If we don't do it within that time frame, we're losing some defenses. It's not like all is lost, but we're losing defenses. And if they initiate due process before we have an IEP in place, then we don't really have an IEP to defend. If we go to due process for tuition reimbursement, there's 3 prongs. So the first prong is that we provided a free, appropriate public education. That's why it's so important to make sure the IEP is really strong. That's the most important prong to win on, that the IEP we put together addresses the student's needs. The second prong is that the parent's private placement is appropriate. That's pretty easy for parents to prove. We rarely win on that prong. And the third prong is that the equities favor the parents. So that's where they have to give us a notice of intent. If they fail to do that, we would raise that at due process as an equities issue. It's not an automatic win for us. Sometimes that can result in a reduction of the amount of tuition that they're entitled to, but that would be an argument that we would bring up. All right, does anybody have anything they want to share about that?
From a practical standpoint, 95% of these notices come in August, about 10 days before the school year starts. So I know this sounds silly, but if you're going on vacation in the second half of August and you're a special ed administrator, have someone check your mail, make sure you check your emails, your faxes, because the 10-day rule is really hard, but the 3-day rule is much harder when you get it, and it's a reality of it. And these are precious. Once a school year starts, some doors are closed, and the worst case scenario is, they wait 10 days and then they submit a hearing request on day 11, and if we haven't reconvened, it's over. We have what we have. So, and we've had some nightmare stories where people don't see these for a few days and it becomes difficult.
Yeah, I agree, Jeff. And this 10-day rule, it's a hard one because the intent of the rule is to give the school district the opportunity to make changes if necessary and to reach some type of resolution with the parent before they're obligated to go through the impartial hearing process. But in reality, what happens a lot of time is the parent has already visited the private school, they've already signed a contract with the private school, and they've made up their mind that that is where their child is going before they serve that 10-day notice. So by the time the district gets it, it's kind of like the parent has already decided what they want to do, and they're just telling you about it to cover cover their bases, but there's very little that you can do to kind of move them off of that position at that point in time. And unfortunately, there have been cases where even if a parent has a signed contract and we've said, listen, this parent didn't negotiate with us in good faith. They had already decided a month before they sent us the notice that this child was going to the private school. Here's a copy of the contract that's dated, July 15th, in which they made their decision, and they didn't tell us about it until the middle of August. There's usually some language in that contract that will say the parent has the right to cancel or something else, where a hearing officer will say, well, yeah, they signed the contract, but that didn't mean that the child had to go to the private school. So school district, you did still have an opportunity to resolve this during the 10-day time period. So it can be a tricky one because by the time we get this notice, oftentimes it's very difficult to change course for the parent, at least.
So we have a very good question. If this applies to any private school or only those that are designed for special education, could the parents request public expense for a Montessori school, for example, because they want a non-traditional or smaller placement? So we are seeing an increase in hearing requests for general education private schools. And it would be more difficult for a parent to prove that that is appropriate to meet their child's special education needs. But we're seeing ways that parents are trying to prove that. So it would be less likely that we would get a hearing request for something like a general education private school, but it's still possible.
Especially if that private school has, specialized psychologists, counselors, other people that would arguably provide the services that the school district would provide regarding those special needs.
But we're seeing, at least in Buffalo, I'm aware of two, like parochial high schools, and they have special ed teachers on staff, and they're advertising that. So, those claims are coming.
Yeah, and so I was just going to jump in and say that. So the other thing that we see sometimes is, in theory, a parent could ask for reimbursement for any school, but sometimes we see them enrolled in a non-public school and they're getting IESP services from the local school district, and that's a sign that the placement they've chosen is not appropriate. And there's good case law on that, and we've had success there. So that's something to watch out for.
Excellent point. All right. On to the next one.
Okay. So independent educational evaluations, these come up, very frequently, of course. So, if a parent disagrees with an evaluation obtained by the school district, they have a right to request an independent educational evaluation, or an IEE. It's a pretty tough rule. When we get these requests, we're somewhat limited in the way that we can respond, and essentially there's really two ways that we can move forward. Now there's some wiggle room, but generally speaking, we have two choices. We can either we have to respond without unnecessary delay, first of all, but in two ways. We can either grant the request and pay for the evaluation, or we can initiate due process complaint to show that the evaluation that we conducted is appropriate. In my experience and working with Jeff and Ann, I think it's been rare that we see an impartial hearing to show that our evaluation is appropriate. Because usually what is happening is the parent is requesting an evaluation that wasn't conducted, and there's federal guidance on that says that's a permissible use of the IE procedures. So that's typically what happens. It's not unheard of, but it's just, in my experience, it's rare. Generally speaking, when a parent asks for an evaluation, I think we see it granted for the most part. So what is unreasonable delay? Does that mean is the next day you have to respond by either filing a hearing request or granting the request? That's not what that means. The unreasonable delay, the case law says that's a fact-specific inquiry, but generally just means you can't sit on it and do nothing. It doesn't mean you can't talk with the parent, try to resolve, and ask what the disagreement is, and try to work it out some way. But you can't sit on it and do nothing. Of course, you can also ask the parents why they disagree with the evaluation. We can't require that. The regs say you can ask why they disagree. but it can't be a precondition to granting the request. Now we can deny the request on other grounds. So this is a related rule, including, so for example, if the independent evaluator is unqualified, if the cost of the proposed evaluation exceeds the competitive rate for that kind of evaluation in your geographic area, or the proposed evaluator is located outside the geographic parameters of the district. So the evaluator is unqualified, or it's too expensive according to your policy, and your policy says what market rates is, or if it's too far away, those are potential grounds where you could deny the evaluation. Now, 2 points about your policies. First of all, if you're going to deny on grounds that the evaluation is too expensive, you need to be sure that your policy is up to date and reflects what the current market rates are, because that can be a basis to have that decision overturned. Okay, so make sure your policies are up to date and reflect the current market rates. If it hasn't been touched in 20 years or 15 years, you should probably take a look at that. And also, if you're going to deny on economic grounds or cost grounds, parents generally have to be given the opportunity to demonstrate that unique circumstances justify that IEE, justify that reasons why that IEE doesn't fall within the district's cost criteria. Maybe it's a particularly specialized provider, or certain evaluations can't be obtained maybe within your geographic area. You need to see a specialist. That may be one reason why it could exceed the cost of your policy. So just want to raise those points. Also, if we remember, this is maybe a 5-year-old decision by now, but an FBA, under this, we refer to as the Trumbull decision, an FBA is not considered an evaluation that triggers the right to an IEE. So if a parent disagrees with the results of an FBA, that does not trigger the right to an IEE. So just want to point that out. Okay.
I think the most important thing to walk away with for IEEs is we can't just say no.
Right.
And we can't just say, well, we'll pay up to this amount, but no more. We can only either pay in full or initiate due process. We could initiate due process to say we'll pay up to this amount, but not more, but you have to initiate due process for that. And that's something that many districts don't realize. And we see that come out in state complaints a lot.
Yeah. I just following up on what Andrew said, it's true. Most cases, the district grants the request, as opposed to litigating. And look, you might say, why? Why does it happen? I think it comes down to money. The cost to initiate an impartial hearing, I think you have to get an attorney, your own attorney, you have to pay them, you have to pay a hearing officer, you have to pay a court reporter. Oftentimes, the cost of the hearing will be much, much more expensive than the cost of the IEE. So that the district says, you know what, I'll save money by granting it. You also need your Board of Ed to authorize initiation of this legal proceeding. That's another issue. Like, do we really want to go that route? So, these are variables to consider, but there are times when the district might say, you know what, this is the 14th evaluation that this independent evaluator has been requested for this person, or this is the 8th, we have to do something about this, or it's too expensive, or maybe a parent has asked for 7 IEEs and those costs are so great that it's worth it. So, but it becomes a business decision in most instances. Any other questions? Just let me see here. Oh, we have a board policy indicating how much the district will pay. Does this provide any support? Yes and no. It provides, so let's say if a parent if the board policy says we'll only pay $500 for occupational therapy evaluations, well, first, they asked for one for 1,000. Can we say we only give 500? Well, yes, but so if the parent could argue at hearing that 500 is not reasonable, it's too low, it's under market rate, and two, as Andrew said, you want your policy to say this is generally our fee cap, but you have the opportunity to show why we should go in excess of that cap. And there could be many reasons for that. So it's helpful, but it's not the end of the story. All right. Let's cruise on to number 9.
All right, topic 9 is the provision of services when a student with disabilities is suspended from school. So we have 3 different rules that we're going to cover. The first one says that during suspensions or removals of up to 10 school days within the school year, students with disabilities are entitled to receive alternative education that is available to all students. So 2 hours each day, elementary level, 3 hours each day, secondary level. However, one difference here is that unlike gen ed students, students with disabilities are entitled to alternative education even when they are not compulsory school age, unlike gen ed students. Does the team have anything to add for the first rule?
So for example, so Katie, if a student with a disability, it's September and they get a 3-day suspension, I think that's what this rule encompasses. What do? They would just get tutoring for 3 days, just like everyone else. It's the most boring of the rules. Now we get to the exciting rules.
Okay, rule 2. During subsequent suspensions or removals of 10 consecutive days or less, that in the aggregate are more than 10 school days in a single school year, but don't constitute a disciplinary change in placement, then students with disabilities have to receive services that are necessary for that student to both continue to participate in the gen ed curriculum as well as make progress toward their IEP goals. And then as appropriate, have to receive an FBA, any behavioral intervention services and modifications. And those are designed to address the behavior that has resulted in that suspension or removal with the goal that that behavior doesn't reoccur. And then you'll see in bold here that school personnel have to consult with at least one of the student's teachers to make that determination regarding the extent of services that would enable the student to both access gen ed curriculum and participate in that curriculum, as well as make progress toward their IEP goals.
So what these 2 rules mean, if you really look at them, which is hard to believe, but it says what it says. It's almost like the FAPE entitlement for the first 10 days doesn't exist according to these rules, which is weird. So basically, rule 1 says the first 10 days, you just get tutoring. Now, I think you should still give counseling or related services or so on. But this rule says you're kind of not entitled to them, which is bizarre. Rule number 2 says if you go above 10 days, but there's no pattern, because if there's a pattern, then you have to do a manifestation meeting. But if you're up to once you cross the threshold of 10 days in a school year, that are not connected by a pattern, you need to take a closer look at the IEP services and figure out how to get, and this is done at an informal meeting between the tutor, the teachers. It's like the tutor calling the teacher going, hey, what should we do? We've got Johnny, he's on day 12. It's January, he's had 12 suspension days. We need to make sure going forward, he's getting special ed, his special ed needs are met. Whether that's related services, whether that's a special ed tutor, whether that's direct consultant teacher services. this kicks in after day 10, but you're not having a CSE meeting, it's informal discussions.
Yeah,
And
that's right, Jeff. Oh, sorry.
oh, sorry, oh, it's weird. But we see advocates at hearings saying immediately they should get full IEP services. And again, hard to believe, but I don't think that's the case under this rule.
That's right. And what makes it difficult from a practical perspective for school districts is that it is very, very hard to find some of these providers, right? How many districts have told us we've been searching for months to get a PT, an OT, to find a BCBA. So providing services, even for the students within the school building, can be a real difficulty. So, compound that by the fact that now you need a service provider to go to a student's home or to provide some type of one-on-one service that is much more difficult to manage and to schedule, it becomes really hard. So I will say in cases like that, that doesn't mean the requirements that Jeff has laid out kind of don't apply because it's difficult, but I will say let's do our best to cover our bases by documenting all the attempts that you've made to try to secure those service providers so that if you are ever challenged, you're able to say, I called 15 different agencies. Here's my record of the phone logs. Here's my record of the emails. We did everything within our power to try to secure a service provider, as opposed to saying, sorry, we just couldn't make it happen. I think we really need to document and make sure that we are showing we've made every effort that we could to secure these service providers.
We had a couple of questions come in about manifestations, and when we need to do a manifestation or FBAs and when we have to do an FBA after a manifestation. So an explicit interpretation of the regulations is we have to do an FBA or consider doing an FBA if the manifestation team finds a connection between the student's disability and the misconduct. So if the manifestation team answers yes to any of those questions, we have to do an FBA, or if one's already been done, consider if it needs to be updated. If we don't find a connection, we don't automatically have to do an FBA. The state points to some regs saying that we need to consider an FBA if appropriate, but that doesn't automatically mean we need to do an FBA. And in most situations, we wouldn't because we found it's not connected to their disability.
So Katie, why don't you try rule 3?
Right, rule 3.
Yeah.
Right, thanks, Kathy.
Yeah.
All right, rule 3, which will round us out for this topic. So this is in situations where there's been suspensions or other disciplinary removals more than 10 school days in a school year, which does constitute a disciplinary change in placement, meaning it's either more than 10 consecutive school days or more than 10 non-consecutive school days where there was a pattern. So in this case, students with disabilities have to receive services, again, necessary to allow them to participate and access the gen ed curriculum, make progress toward their IEP goals, and then as appropriate, an FBA, any behavioral interventions and modifications designed again to address the behavior that resulted in that violation so that the behavior doesn't reoccur. And then the emphasis with this rule is that the interim alternative education setting and services is determined by the CSE.
That's clear as mud, right? Now my take on that rule, Katie, is what this means is 2 rules here, 2 situations. The most common, if you're over 10 days, non-consecutive, and there is no pattern, there's no nexus. There's no nexus. So this could be a long-term suspension or a short-term suspension over 10 by a pattern. If there's no nexus, the CSE has to meet to determine the student's program and services during the suspension. And it's confusing because they use the term IAES and they use that for different things. But basically, if there's no nexus and there's going to be a long-term suspension, the CSE formally meets to determine the program. I also think if it's connected by a pattern and there's Actually, if there is a pattern, a nexus, and it's over. So this is, sorry, it's only one rule. It's in a case where there's no nexus and the student's going to be suspended. So that's in contrast to the previous rule where it was just an informal discussion. I know at least in Western New York and in Rochester, the state has been really strictly enforcing this rule.
That's right, Jeff. And one thing that I think is a little bit of a conundrum here, and Anne touched on it earlier, was the need to do a FBA, that functional behavioral assessment, and a new BIP before moving a child to a more restrictive setting, right? So what we see sometimes is a student is suspended for engaging in, some really off the wall behavior. Maybe there's a manifestation. They may not find that there's a nexus necessarily, or even if they do find that there's a nexus, but in either event, the committee determines that the current program the child is in is not appropriate. Can you just automatically move that child to a more restrictive setting, or do you need to keep the child where they are and give yourself an opportunity to do the FBA and the BIP, try that out a bit, and then move them to a more restrictive setting, which can take time, absolutely, to collect that data, even though they've already engaged in this off-the-wall behavior and almost everyone in the room feels like, okay, they shouldn't be in this current program anymore. And I don't know that there's a strict legal answer to that, but I think that's kind of a real world problem that some districts face at times.
It's about half of our hearings right now, right? It's yeah, and the district says we know it's time to go more restrictive, and parent says no, we didn't try everything, and then that's the great. What will the hearing officer say? We should have tried more. It's to some degree depends on the hearing officer too. It's a tremendous risk. So
We have a question. My understanding is there could be a pattern, but not necessarily a manifestation of the disability. So yes, a pattern determination is a totally different analysis than a manifestation determination. And you could have no pattern, but it would be a manifest, or you could have a pattern and there is no manifest. They're totally different inquiries.
Yep, right. And it's a common mistake. If you're sitting at a manifestation meeting to see if asking whether there's a pattern, you're doing the manifestation analysis wrong. Okay, we're on to the last slide.
Okay, last slide. Okay, let's round us out with reevaluation. So under the regulations, a CSE shall arrange for an appropriate reeval of each student with the disability if the school district determines that the educational needs or related services needs of the student, including academic achievement and their functional performance, warrant that reevaluation of the students. Or if the student's parent or teacher requests a evaluation. So this can be done not more than once per year unless the district and the parent agree, and it must be done at least once every 3 years unless the parent and district agree in writing that it's not necessary. So this is what we typically refer to as that triennial, that every 3-year evaluation, not to be confused with the annual review of the student. So I just want us to be clear that yes, these reevals need to be done every 3 years, but that doesn't mean we give a student an IEP and then we kind of fall back for 3 years and then we look at the student again. We should be, of course, doing these annual reviews of the students to make sure that their IEP is appropriate going into the upcoming school year, which means that, of course, we need to make sure whatever evaluations need to be done as part of that reevaluation, because the reevaluation is kind of the umbrella term, right? That reevaluation may include many specific evaluations. Maybe there is a new psychological evaluation that's done. Maybe there's a new health exam that's done. So it can include a lot of different components, but we should be making sure that when we believe the student's needs have changed significantly and we need better, more updated data regarding that student, that we are requesting those reevaluations. And I think we're running short on time, so we'll just move right to the next slide, which is part of reevaluations in terms of who is going to conduct the reevaluation. So that reeval must be conducted by a multidisciplinary team or group of persons. It must include at least one teacher or another specialist with knowledge of the student, and it needs to be sufficient to determine the student's individual needs, educational progress, and achievement. Any results of the reevaluation must be addressed by the CSE in a meeting to review it, and if necessary, we're going to be revising that student's IEP. And rather than having a standalone reevaluation meeting, it makes sense, and the regulations specify that when possible, we should be encouraging the consolidation of those reevaluation meetings with other CSE meetings for the students. So if your annual review and your reevaluation happen to fall at roughly the same time, you can cover all of that within one meeting. Do we have questions on the reevaluations topic?
I think we had some questions dealing with, they were sort of nuanced with students with IESPs and homeschooled who deny services, and do we continue to reevaluate? That's a tricky issue. Whoever asked that question dealing with, communications with the parent. But Candace, I think you hit all the main points. One thought in terms of the substance of the reeval is it's very helpful if we could show that we ask the parent for their input when we do the reevals, to say, hey, what do you think we should cover in this next round of testing? Even if you put in your consent form, like we want to do a psych and a observation, do you please put some other tests that you'd like to see done? That's super helpful on a lot of levels. So make sure we can get the parents' input in there.
Yeah, that's a great point, Jeff, because it reduces the likelihood that they'll ask for that IEE that we talked about earlier, because left to their own devices, they can go and choose the most expensive evaluator and maybe have circumstances that are less than ideal if we had first considered doing the evaluation ourselves.
Right. And it looks like there's some questions about, can we consider private evals in lieu of our own evals and testing? And that's just a risk assessment. The district, if you'd like to, when figuring out, if you have fresh data from an outsider and you're confident with that, then that's something to take into consideration. I think though, depending on the evaluator, if they see things in a certain way, or maybe they were chosen to support a parent's position, you may want an objective district evaluator to get some testing too. Then you could have other issues. Anne would know more about this, about, well, if an outside evaluator does some testing, can the district do those same tests? Does that invalidate the tests? So that's something to consider.
Yes, it does. I think a risk with not doing our own testing is it's difficult to refute the recommendations made by the outside evaluator if we don't have our own data around that. So I, in general, recommend that we do our own assessments and we consider both. But yeah, we can't give the same test as the outside evaluator if it's been given within a certain period of time. But there's plenty of alternative assessments we could give that measure the same things.
Right. Especially in a reading case, when like methodology is pushed, it's very helpful that the district have its own testing. Okay, well, let's go to honorable mention. There's two very quick ones. These did not make the top 10, but we figured we'd mention them anyway. Don't forget prior written notice. It's a bedrock principle of special education. Anytime the district proposes or refuses to do anything involving identifying, evaluating, or placing the student, or providing a FAPE, which is basically anything it does, it has to give written notice to the parent. And the notice needs to be provided before the district takes action, and theoretically with enough time they could challenge it. So districts are pretty good at this, but try to personalize the prior written notice letters when possible to get you the A+ for that. Let's go to the next slide. This is all just a ton of required information. Know this list, put other factors. It's very, especially when we the other factors considered are very important. Don't just say what we decided. Also write what we considered and why we didn't go in that direction. Very helpful. Ideally, you're starting to have these discussions at the CSE meeting and then carry over. But this would carry over into other decisions by the CSE, but related to the program, outside of the CSE. So think broadly on that. I don't know if anyone has any comments on prior written notice.
We had a question about how detailed prior written notice needs to be. It's supposed to be detailed and individualized to the student. Using just the generic language that comes out with the IEP program you use is not sufficient. But obviously, the more significant the meeting, the more intense the meeting, the more detailed you need to be on the PWN. That
was going to be my point. It's can be frustrating preparing for a hearing and you look at a prior written notice and it contains only that stock language that's generated right within the form. That's tough. So I know it takes time, even if you have somebody else preparing it for you. I mean, the person who chaired that CSE meeting probably should take a look at that PWM before it goes out.
And sometimes if it's the case that you think could get litigated, it's a good idea that you could send it to us. We'll take a look at it. Give you some thoughts on that as well. Extra set of eyes. All right, last topic, last honorable mention, timing of the CSE meeting. This is something that's so obvious, people forget it. We have to arrange for the parent to receive notice in writing at least 5 days before the meeting. Not 5 business or school days, 5 days, and it's receipt. So 2 related rules. First, the parent and district may agree to a shorter time period. And the other related rule is if we're dealing with discipline-related issues where the CSE is involved or a manifestation meeting is held, then the 5-day rule does not apply. We're allowed to take action in conformity with the other rules. So, if we realize if the student is at day 8 and they're about to have a 5-day suspension, and there's a nexus, and yet you have to have a manifestation meeting within 2 days, you obviously can't get 5 days notice for a manifestation meeting. Or if there's going to be a no nexus found, therefore we're going to have a CSE meeting to implement. You can't wait 5 days. You have to do it in 2. So you could do it in a shorter time period under those situations. Fun times. Any other, I think, and I believe that covers everything. We only went a few minutes over, which is great. We were able to answer a ton of questions. Any final remarks, comments, questions, thoughts by the panel? All right.
No, just want to thank everyone for attending and have a great rest of your summer, everyone.
Yes. All right, everybody. Enjoy your summer. We'll be back in the fall with more programs, and reach out to any of us with follow-up questions. Take care, everybody. Thank you.
Thank you.
Thank you.
Bye-bye.